Are we ready? Good afternoon. Welcome to the Senate Finance Committee. Today is Thursday, February 1st. We're going to hear 9 bills today, and I'll read the order. I am going to say we have one bill that has 62 witnesses. That bill will be limited, the witnesses will be limited to 1 minute each. You know, you can't say a whole lot different when there's 62 witnesses. So if you just say I support and me too, that's a fine testimony. And you don't need to start each testimony with my name and the vice chair's name and the committee. Just get right to your testimony. We're happy to hear from you. We're happy you're here. So thank you very much. As I said, today's Thursday, February 1st. The bill order is Senate Bill 232, 233, 91, 84, Senate Bill 109, 133, 192, 38, and 160. You will see senators coming and going. It's not that they don't want to hear from you. They are testifying on bills in other committees. So please do not think that they're just leaving to go out and have coffee or something. So thank you very much. And we're going to start today with Senate Bill 232. I should have someone from the department here. Michael Hayes. Is Michael Hayes here? Thank you. So Senate Bill 232, Public Employee Relations Alterations.
Yes, thank you. I had a different number. I apologize. Chair Bidel, Vice Chair Klossmeyer, all members of the Senate Finance Committee. I will say my name. It's Michael Hayes. I'm Chairman of Maryland's Public Employee Relations Board, or PERB. Thank you for the opportunity to testify on a departmental bill to clarify some aspects of the 2023 Maryland Public Employee Relations Act, or PERA. PERA has also submitted written testimony. I'll be brief. The bill adds a definition of the term interested party used in PERA regarding representation elections. That's just to clarify to what employee organization it refers. It's used elsewhere in the bill, and we thought that was necessary. The bill changes references to unfair labor practice complaints to charges, as both terms are used in PERA, and the change is consistent with the National Labor Relations Act, which refers to charges filed by parties and complaints issued by an agency. Finally, the bill would permit PERB deputy directors to be assigned to any unfair labor practice within the PERB's jurisdiction, instead of one being assigned to a specific type of employer. In PERB, we found already at some points in time, we have lots of public school cases. Other times we have lots of state government cases. Still other times, a lot of higher education cases. The proposed flexibility would enable deputy directors to get cases sooner and would also avoid imbalances in their workloads. I respectfully request a favorable report on this bill, and I'm willing to answer questions, if any.
I see a question from Senator Lamb.
Thank you, Madam Chair. Just a brief question. Thank you, Mr. Hayes, for being here. This stems from the legislation I guess I sponsored last year to consolidate the 3 labor relations board into one, right?
That's correct.
And so
yes.
All of this is really just kind of cleanup of things that may have been accidentally left off. If you can just let us know also how that consolidation is going and how the staffing is.
The staffing is good. We now have 2 deputy directors. They're busy. Both have a lot of cases. We've done a number of elections. It's all going very well. So we thank you for sponsoring that bill, and we're very proud to enforce it.
Okay. Is staffing fully staffed yet or still?
Oh, thank you for that question. The governor's budget calls for a 3rd deputy director, which was called for in the legislation, and that would happen after this fiscal year ends, is when we would have to start hiring for that, because it'd be in the FY 2025 budget.
Fiscal year starting July 1st then?
Yes.
Right. Okay. Thank you.
Senator, do I have any other questions for Mr. Hayes? That ends the hearing on Senate Bill 232. Thank you.
Thank you, Madam Chair.
Our next bill is Senate Bill 233, and I have Deviki Burke is the sponsor from the Maryland Department of Labor. And I think she's bringing with her panel, Christopher Meyer, David Rodwin, and Mike O'Halloran. No,
Sorry.
No. Oh, I'm sorry. No, that's not right. Not who am I? So I'm only going to start with Chris, with. Okay. So will the sponsor and
Yes, thank you. I'm Devki Verk. I'm a Commissioner of the Labor and Industry Division of the Maryland Department of Labor. Thank you for the opportunity to testify in favor of Senate Bill 233 today. My division, among other things, enforces the wage and hour protections that the General Assembly has enacted for Maryland workers. What this bill does is provide protection for employees who report potential violations of those provisions to us or to their employer, and protects them against adverse action for doing so. As you would see from our written testimony, each one of these laws differs in its approach to anti-retaliation. Some of the laws have no, and there's a chart that I included in there. Some of the laws have no protection against retaliation for employees who report. One of them, our wage and hour law, only has as a remedy a criminal misdemeanor, which to us does not appear to be a reasonable way of protecting people who report these potential violations. And there's just a mishmash of different provisions that are in each one of these laws, if they exist at all. What this bill seeks to do is two things. It's to provide a uniform administrative process for addressing claims of retaliation, and provide a uniform set of protections for employees who report. We have presented this bill in the House, and based on some of the feedback that we received from the members of the House, we've discussed with the chair of the subcommittee on business regulation of Economic Matters Committee, 2 amendments to this bill. The first of those amendments, the first amendment addresses an issue that was raised by a number of businesses, and that was a concern about employees filing frivolous claims. In order to address that, we suggest an amendment that imports from one of our other wage and hours laws, the Workplace Fraud Act, a provision that allows employers to address claims, frivolous claims and abuse of this process by employees by filing a complaint with us. Sorry, does that mean my time is up? No, sorry. We suggest that that provision be imported into the anti-retaliation scheme that would apply to all of these statutes. Second, we suggest that there be a uniform and exclusive administrative process for addressing claims of retaliation under all of these laws where an administrative process does not exist. As you'll see from the chart, there's really only one law, and that's the prevailing wage law that already has an administrative process. None of these other laws does. And so we suggest, instead of having a multiplicity of different kinds of forms of redress and processes, that we have one single administrative process to address all of the other retaliation claims that could arise under any of the other statutes. Those are the 2 amendments. I'm happy to speak further, but I know my time may be up.
no, you have as much time as you need. as
Oh,
the sponsor.
okay.
So I do have a question though. Are you going to be drafting the amendments or sending the amendments to
Yes,
council?
yes,
Thank
we
you.
will do that. We have submitted them to the sponsor, to the subcommittee chair in the House, and we would be happy to do that the same with this committee.
Thank you. If you have more,
I guess I would just add this from the standpoint of the department that is responsible for compliance with our laws, Senator, and that is this kind of a bill. And again, we're willing to work around the edges here, but some protection against retaliation is necessary to make the laws that this body has passed that set the labor standards in the state actually mean something. I will tell you that a significant number of wage payment and collection claims that we get and violations, alleged violations of the wage and hour laws that we get are from people who have already separated from employment. And that to me is telling. Their pay, their overtime pay has been wrong for some time. They may have known it for some time, but the point at which they choose to report to us is the point where they are no longer vulnerable as employees. And it seems to me and the staff of the division that in order to change that, in order to increase compliance, we have to give people some protection when they choose to exercise the rights that they have been conferred by this General Assembly to protect themselves in the workplace. Thank you.
Thank you. I neglected to say this in the beginning, but the sponsor gets as much time as they need. It's everyone else that gets 2 minutes, except if there's more than 30 witnesses, they get 1 minute. So that's kind of the rules of the committee. So
Thank you. I appreciate
So
that.
do I have any questions for this sponsor? Senator Reedy?
Thank you, Madam Chair. Two questions. One is, when you say there is no protections for someone who brings an action, an employee, a whistleblower, but you said in the law there is a misdemeanor prosecution. Are you saying there's no protections that are administrative protections when you say there's no protections? Or?
Well, that's a good question. So it differs from law to law, and we put a chart in our written testimony. For child labor, for instance, someone who reports a potential child labor violation, they can be fired for that without any redress of any kind under state law. That's subtitle 2 of the Title 3 of the Labor and Employment article. There is no anti-retaliation provision in that. The Living Wage Act, which applies to state-funded service contracts, there is no anti-retaliation provision in that and no redress at all.
So
the
and I'm not trying to interrupt you. I'm just if I work somewhere and I see that they're violating a wage law, the living wage law, and I go complain to Department of Labor, you're saying right now, and my boss fires me, there's no recourse?
Not under the living wage law, not under any law
Okay.
that I'm aware of, correct?
Okay, and then secondly, that one of the opponents in the bill, one of the people who's raising some concerns mentioned it is treble damages. Is it fair to say we're saying you can enforce up to treble damages on an employer for any of these kind of violations?
So for retaliation, yes. So the way that the process that is included here, the administrative process, was taken from the Family Act's anti-retaliation provisions. And what that process says is that all complaints come to the commissioner. We investigate. If we determine merit, we issue an order. And then if the employer does not comply with the order, then there can be enforcement either by the individual through a civil process or by us or the Attorney General,
Okay.
also through a civil process. And then and only then would
Would you issue-
damages come into
Okay.
play, correct?
And so the employer can appeal something also if
Of
there's
course.
okay, all right, thank you, Madam Chair.
Senator Hershey?
Thank you, Madam Chair. Maybe following up on that, if there is a complaint that an employer has violated one of these laws, and you have them listed: minor labor, equal pay, wage and hour, wage payment and collection, workplace fraud, prevailing wage, living wage. Do you have the data for the number of complaints for violations of these that we're receiving, that your office is receiving every year?
Thank you for that. If you mean violations of the actual law itself, like someone who's not getting paid
Correct.
timely, et cetera, we do have data on that. I've been in the job for 8 months. I should know this, but I don't know if we break it down by law or if we group all of the wage program complaints together. But I would be happy to get you that information.
Okay, if you could get that, that'd be appreciated. And then the next step would be, are there claims for retaliation?
Under the prevailing wage law, we have
Oh.
received some complaints of retaliation. And I would say that's because that's the only law that really has an administrative process as well as a private right of action already.
And so, again, if we were looking for, you have data on how many claims there were for retaliation?
I can tell you that when I came into this job in May of last year, we began taking those claims. My understanding is that previously retaliation claims under the prevailing wage law had not been consistently processed by our office, and I do not know that there is any data around that. But since I came in, I'm aware of 2 claims that we are currently in the process of processing.
Two claims.
2, yes,
Under
under the prevailing wage.
And
law,
that's
correct.
prevailing wage because there's administrative process there. We don't know the other ones.
We do not know the other ones, right? And the bill, just to be clear, since prevailing wage already has an administrative process that appears to be working. This bill, as amended, if our amendments were accepted, would exclude the prevailing wage law from this piece because it already has
Okay.
a process.
All right, but just 2 claims so far.
2 claims in the last several months, yes.
All right, thank you very much.
Thank you, Senator. I don't see, oh, Senator Mounts.
Thank you, Madam Chair. I apologize. I was a little late getting in and I missed some of the hearing. But if there's an adverse decision, what would be the appeal for the employer? Is there an appeal for an employer? I guess that's a better way to put the question.
Certainly, if in the administrative process itself, there is a contested case hearing process under the Administrative Procedure Act. So on the merits itself, the employer certainly has a full opportunity to address, its arguments to an administrative law judge. And should an enforcement order be sought, the employer could then raise those issues and attempt again and bring an appeal on whatever the bases were that they raised before the administrative law judge.
Would that appeal be through the administrative process or through court?
That would be in court.
That would be in court.
And again, this is my understanding of the process. There's an administrative process at which merits are determined. And that is a contested case process under the Administrative Procedure Act if the employer chooses to contest. Once a final order has been issued, the commissioner can try to enforce that order in civil court, or the individual can take that order and attempt to enforce in civil court. And at that point, the employer again has an opportunity, if an order is sought against them, to raise points on appeal at that point.
And that appeal process, that's under that currently exists. Am I correct in assuming
Yes.
that? And would the legislation change that in any way?
It would not. This process, and thank you for that question, was taken from the Family Act. It's a duplicate of what was enacted by the General Assembly and the
Right, but
Family
it
Act.
doesn't currently exist right now for these specific,
I believe that it does. There are other laws in which, and I think even some of our substantive wage and hour laws, when an order is issued after an administrative process, there is, and it is not complied with, there is a process by which the commissioner or the attorney general or the individual can go to court to attempt to enforce that. And again, at that point, the employer can make the arguments to the court that it's not a proper order for enforcement for whatever sets of reasons that they could bring on appeal.
thank you very much.
Do I have any other questions? Thank you very much for your presentation.
Thank you.
Is Christopher Meyer here? He signed up in favor. You're welcome to come up, and then we'll hear from Mr. Rodman in favor with amendment. Thank you.
You don't want to go first? All right. Thank you, Madam Chair, members of the committee. My name is Christopher Meyer. I'm a research analyst with the Maryland Center on Economic Policy. I'll take my mask off. In strong support of Senate Bill, this is 233. I apologize. I just got in here. So Maryland's labor laws can only be effective in raising wages and protecting workers if there are strong and effective enforcement mechanisms. And that starts with workers being able to report violations. And the threat of retaliation is pretty obviously a major barrier to that. Our labor laws are both heterogeneous in their protections against retaliation and in general deeply inadequate. Senate Bill 233 would strengthen those protections. So we support. Otherwise, I concur with the sponsor's testimony and I ask for a favorable report. Thank you.
Thank you. Do I have any questions for Mr. Meyer? Thank you very much. Mr. Rodwin is signed up he's from the Public Justice Center, favorable with amendment.
Thank you, Chair Vidal, Vice Chair Klausmeyer, members of the committee. David Rodwin from the Public Justice Center. I lead our Workplace Justice Project. Current Maryland law on this issue is there were some facial expressions that I think are totally reasonable in this circumstance. A worker can get fired right now for reporting to the state a child labor violation. A worker can get fired right now for reporting to the state that they are not getting paid overtime wages. there is nothing they can do about it under state law. We tell workers all the time that information when they're deciding whether or not to even make a complaint. Previously, the state wage complaint form did not even have a way that you could report that you were retaliated against. So when we're talking about tracking violations, there wasn't even a way to report it, let alone track it. We often, in counseling workers as to what to do, have to honestly share with them that remedies may be severely limited if they report the violation and are retaliated against. Federal law does not have this problem. Under federal law, if the employer is covered by the Fair Labor Standards Act, the worker can file a complaint and gain the protection of that law. Just to break it down sort of more concretely, we represented some home care workers in 2019. We filed a lawsuit. The home care agency fired all of our clients immediately. We went to court the next week, got them reinstated. They didn't even lose a single paycheck. If that employer had not been covered by the Fair Labor Standards Act, there is nothing those workers could have been done. These were minimum wage workers earning, at that time, $11 an hour. So this bill is critically important. Our amendments were, candidly, we think it could go farther in better protecting workers, ensuring that all relevant statutes are covered and that workers have a right to go to court immediately without just the administrative process. But anything is helpful, and we ask for a favorable report. Thank you so much.
Thank you, David. Any questions for Mr. Rodwin? Oh, Senator Reedy.
Just quickly, and maybe I'm learning something. So what kinds of employees are not covered by federal fair labor standards?
Federal, and thank you for that question, Senator Reedy. Federal law is limited by the Commerce Clause in terms of what employers are deemed to affect interstate commerce. So employers that are above a certain size are typically deemed to affect interstate commerce. But lots of employers, you can employ 15 people.
So small businesses generally could be,
small to medium, and then also depending on the industry. Some industries are deemed to have a more direct effect on interstate commerce than others.
Okay, thank you very much.
Thank you.
Thank you, Senator. Any other questions? Thank you very much. So that ends all the favorables. So
Thank you.
thank you.
Appreciate your time.
Thank you. I have Mr. O'Halloran and Tommy Thompson. Unfavorable. Thank you.
Sure. Thank you. And good afternoon, Madam Chair, Madam Vice Chair, and members of the Finance Committee. Thomas Thompson on behalf of the Associated Builders and Contractors in opposition to Senate Bill 233. You've heard some explanation as to this bill, but the bill itself as drafted, and I'm glad to hear that there are amendments because functionally in a court setting would have some problems. You have retaliation statutes ingrained in 4 of the 6 statutes that you're asked to review today. This is a standalone provision that has its own mechanisms, and though that's administrative, it is going to be confusing when you try to reconcile those 2 laws against themselves. What's even more important and was not discussed as an amendment is on page 2, lines 5 through 6. That gives the the employer may not discharge or demote or discriminate. It gives all those things the employer cannot do based on the fact that an employee made a claim. So you could have an employee on a construction site for ABC, for example, who made a claim, but is smoking marijuana and then wants to go use the crane. And the employer should have the ability to fire that individual for violating their workforce drug policies. But the way this is written, it should probably say solely because they filed a claim. You shouldn't be able to terminate them solely because they filed a claim to the Department of Labor. But you shouldn't give them the broadest protections in the world simply because they filed a claim. They may otherwise be a terrible employee. I do have some trouble with the punitive damages in this case. Treble damages, if you think of them in their purest sense, are 3 times the amount of the award. That is a punitive damage. It's simply capped. So you have a punitive damage piece to this bill, and then you also have a kind of open-ended punitive damages piece as well. I think that also should be looked at as the committee because it's pretty draconian to double dip in that fashion. I'm also glad that the department has asked for an amendment to bring over some employers' protections because there are times when employees make frivolous claims, and it is the department's responsibility to represent not only employees, but employers, because without employers, there's no employees. And I thank you.
And our last witness,
Good
please.
afternoon. I can take a hint. I'll be brief, Madam Chair. For the record, my name is Mike O'Halloran here today on behalf of NFIB. Certainly want to echo a lot of the comments of my colleague, Mr. Thompson. I too am happy to see the Department of Labor is entertaining some amendments that I hope to look over myself. Let me also start off by saying, neither I nor I would guess Mr. Thompson is up here to protect against bad actors. But what we see here, and even by the commissioner's own admission and during the House hearing, is there already exist very, very robust enforcement mechanisms for the department and for the employee to take advantage of if they feel that they are wronged. I think the issue here is what's changed, what has manifested this bill. And when I asked the department, Senator Hershey, to your point, when I asked the department has there been a sudden uptick in these complaints? And the response that I received was no, there has not. And I further asked, why do we think that is? And the response was, well, yes, these employees do have access to the courts. They can file a claim in court, but we feel that is sometimes just out of reach. And I would proffer to this committee that, look, if there is an issue, if an employee has a legitimate claim, there is certainly, I would venture, even the proponents would be willing to look at that. And if the claim is legitimate, they will proceed. So, while the department tries to couch this as standardizing across these areas of law, I would counter that and say, yes, this does create a standard, but it's not standardizing. Instead, it is just adding yet another very heavy-handed tool for the department to go after employers. And again, I'm not up here defending bad actors, but you and I both know that, the anecdotal evidence is voluminous of employers, your constituents saying, hey, I'm getting, a pretty threatening letter from, the department, from an agency. What do? I don't think I did anything wrong. Thank you, Madam Chair.
Thank you very much. Any questions for Mr. O'Halloran? That ends the hearing on Senate Bill 233. Thank you. Next, we'll hear Senate Bill 91. Senator McCray, you have as much time as you need to present your bill. Do you have a panel, Senator?
Yes, ma'am.
Would you like to bring your panel up?
Yes, please. How you doing, sir?
Okay to begin?
Yes, please.
Thank you. Madam Chair, members of the committee, first, for the record, Corey McCray, Senator for the 45th Legislative District. And today I'm here before you in reference to Senate Bill 91. I'm also going to be respectful of the time because I do have 4 panel members here with us today. But in detail, what Senate Bill 91 does is it sets up a program within our Maryland Department of Labor to make sure that we kind of emphasize or complement programs that already exist currently in Prince George's, but looking at Baltimore City and Prince George's at this moment, how we're working with our community to make sure that we train them up in reference to those folks that are working or maintenance in our multi-housing spaces. It's a great opportunity, but I think that you'll be able to hear best from the folks that's actually doing the work, I should say. And Madam Chair, I just hope that we get a favorable response in reference to Senate Bill 91. Thank you.
Thank you, Senator.
Yes, ma'am.
Madam Chair and committee, good afternoon. My name is Walter Simmons. I serve as the Executive Director of the Prince George's County Workforce Development Board and the President and CEO of Employ Prince George's. Through our work, through the pandemic and now recovering from the pandemic, we've seen a lot of job loss. I'm talking about resident workers. The state of Maryland has lost over 100,000 workers when you compare 2019 to 2023. During that time, we've also seen housing increase. We've seen housing affordability decrease. So when people are walking through our job centers, needing livable wage employment and needing to afford housing that don't want to pursue or don't have access to a college degree, we have to figure out a way for that working class Marylander to be able to afford to live in Maryland. We also believe that training programs should start with the business. We need to be training people that leads to jobs and these residents to be able to meet the needs of local businesses. We found that match with the Maryland Moulting and Housing Association. We knew that when people got a job with an apartment complex, sometimes those apartment complexes lead them to discounts on their rent, which leads to housing affordability. We also knew that rental housing is increasing and they need workers to meet the need. And we also had tons of unemployed people and people dropping out of our labor force. And so what we identified as a 4-week program that is created by the business, that we were able to put high school graduates into this program and pilot in Prince George's County. And we've done 3 cohorts. Candace is going to talk about 80+ job placement rate for those, 90+ completion rate. So that's high school graduates being able to graduate, get a job because the employers have created the training, and we've seen a 90% graduation rate, 80% placement rate with a livable wage career for somebody at high school, and this is after only a 4-week program. So we're hoping that we can see this program grow to Baltimore region and across the state as a way to decrease unemployment, increase wages, and increase housing affordability by increasing the wages of middle-class workers.
Thank you. And next.
Hello, my name is Candace Manning. I'm currently the Director of Workforce Development and Training for the Maryland Multi-Housing Association. Prior to my role here, I spent 15 years working in the multifamily industry. I actually fell into the multifamily starting in leasing, working my way up to a property manager of multiple sites, and a career in property management has afforded me the opportunity to raise my daughter as a single mother and also to purchase a home and have a livable wage. I was fortunate enough to have the opportunity to create the Leasing Training Academy from scratch. As a hiring manager for almost 15 years, I was able to identify learning gaps to help people get employed. We launched the program a little over a year ago, and we have created a unique structure where we have 22 different owner-manager companies who have agreed to consider our students for employment. Simply put, our program works because not only is the curriculum relevant, but we've partnered with people who are hiring so that we can ensure our grads get jobs or at least create the opportunity. The other part that I must mention about this program is that a lot of our graduates are exposed to one of the challenges for hiring managers in our field is the soft skill portion. The last week of the program is dedicated solely to soft skills so that we can help people successfully transition into professional roles. And these are people who never thought they could have professional roles or careers. The people that you see in the leasing office are not just leasing an apartment. This is a career path. And if you work hard, it is a career that is sustainable and can really be life-changing. I urge you to support Bill 9-1.
You.
Hello, my name is Caitlin Strom. I work with a management company that has had the pleasure of reciprocating some of the students that have graduated from the Leasing Training Academy. I've been with my company for 10 years, and we had worked incredibly hard to find the correct way to train people to do exactly what they need: the customer service skills, the soft skills, the professional skills of what is needed to rent somebody their future home, because it's not just an apartment, it's where they live, they breathe, they have happy moments, they have sad moments, and to be able to effectively present that skill is very difficult to some people. So we've had the luxury of having some graduates. They are still employed with us. One, was able to take a rent discount and lives with on one of our communities as well. Our company worked hard to ensure that we had a career pathing for our team members, and this person has excelled. Some of the people that have worked with us for years, they're topping what their coworkers are doing because they've had this skill set set forth beforehand. I've personally had the luxury of going in, assisting, and sitting in on some of these courses and classes, and the start from day one where they're at to where their graduation day is, it's 150% turnover, and they are incredible. And I think it's an amazing portion to present for everybody. Thank you.
Good afternoon, Madam Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association. I'll be very brief. We have our written testimony, and you also have written testimony from some of the students in the program. We're going to have some of them testify, but given the significant number of witnesses you guys have today, we want to be brief for the committee. The program works as succinctly as I can be. The program works. They connect people, they train people, and they connect them with jobs. We have had immediate success, as Mr. Simmons noted, more than 82% placement rate for the first 3 cohorts. These jobs pay well. They are life-changing. And as a state, we do a really good job of talking about workforce development and talking about housing, but we don't talk about them collectively very often. And so this bill, I think, is a unique way and a first step, hopefully, to expand that discussion and talk about housing and workforce development simultaneously, especially as we see more bills from Governor Moore's administration that will increase housing and housing density in the state. We're going to need those workers. Thank you very much.
Thank you. Do I have any questions for this panel or the sponsor? And there's no opposition, so that ends the hearing on Senate Bill 91. Thank you.
Thank you, Madam Chair.
Senator Guile, Senate Bill 109, State Employees Parental Bereavement. And you have a panel or someone with you?
Good afternoon, Madam Chair. For the record, Senator Dawn Guile from District 33. And I have here with me Lauren from Anne Arundel County, who is also a state employee. Will be testifying on SB 109. SB 109, as introduced, would entitle any state employee to use up to 10 days of paid parental bereavement leave within 60 days after the death of an employee's child who is younger than age 21 or after the employee experiences a stillbirth. This bill is reading the testimony, it's difficult to read, especially as a mother myself of three girls and of 3 babies, and having, had to experience personally going back to work after having children. And I can't begin to fathom the profound grief that parents experience when losing a child. And in such a tragic event, adequate time is needed for self-care to give the attention later that one needs to do to get back to work. Under existing law, state employees who lose a child are entitled to use 5 of their accrued days sick leave or may take up to 3 days of bereavement leave. After working with some stakeholders on some amendments, I have submitted an amendment in response to that feedback. And SB 109 as amended would entitle state employees and employees of a public institution of higher education to include them up to 60 days of parental bereavement leave if the employee experiences a stillbirth or a death of an infant under the age of 6 months. So they would be allowed to use that full parental leave that they would have otherwise have had they had, a child who had lived. It would also entitle state employees and employees of a public institution of higher education up to 10 days of parental bereavement leave if the employee experiences the death of a child of at least 6 months of age through age 27. Passing this bill isn't just the right thing to do from a compassionate perspective, but it's just the right policy for our state. For these reasons, I respectfully request a favorable report on SB 109, and I have here Lauren for her testimony. Thank you, Madam Chair.
Good afternoon. Thank you for allowing me this opportunity, and bear with me. I'm Lauren Ryder. I'm testifying personally, but I do work for the Department of Social Services under the purview of the Maryland Department of Human Services. I graduated with my MSW from UMB in 2014 and have worked with DSS for the last 9.5 years. I supervise 7 staff who go into homes following a CPS investigation to ensure the permanency and the well-being of children in their home environment. Just over a year ago, I gave birth to my son, Noah. He was immediately taken to the PCICU at Hopkins, where he lived for 20 days, receiving 2 surgical procedures. I can count on one hand how many times I was able to hold my baby, one of them being the 2 hours leading up to his death. The minute that his heart stopped beating, was the minute that I was no longer qualified for the 8.5 weeks of parental leave that I had been approved for. Despite the fact that I gave birth just like all other mothers, the only leave I qualified for was 3 days of bereavement leave. Why is a grieving mother expected to return to work after 3 days when a mother whose baby lives can get up to 12 weeks of parental paid leave? Sure, I could have used my sick leave, but I wasn't sick. I was grieving. And what would I have done if I got sick? It would have been irresponsible for me to return to the job I do for DSS in the devastated state that I was in just after 3 days. Noah's funeral wasn't even planned after 3 days. Please take a minute and really think about this. The right thing to do is to vote in favor of this bill. Please lead the charge and make this change. Thank you.
Thank you for your testimony and please accept our sympathy. I know that was really difficult for you. Thank you for sharing that.
Thank you.
Do I have any questions for Senator Gile or her witness, Ms. Reader? No questions. Thank you. We have one more person favorable with amendment, and that's Denise Gilmore. Thank you.
Denise Gilmore with AFSCME Maryland. Just want to come out in support of this bill and thank the senator for introducing it and for also working with amendments on us. Obviously, the worst call that you can have as a union representative is from an employee who's gone through a terrible tragedy and has to choose between going on like unpaid leave status or, being able to actually take the time that they need and more. And so this is a really important bill. The sister who spoke mentioned she was a supervisor. I would be remiss to say that the reason we need legislation is because while we could negotiate this in a contract, obviously if they're not represented, then we need legislation to cover them. So we really urge a favorable recommendation, and we're going to talk later about a bill where we can potentially get them into collective bargaining rights. But
thank you, Denise. Senator Hershey, you have a question?
Thank you, Madam Chair. That's exactly the line of questioning I was going to go down. Why is this not done in labor negotiations? Because they're not represented? Is that what you were saying?
Yeah, it's pretty common. I mean, since, I've at least been here, but we can, certainly always engage in the conversation with management first. But then if we want, what we negotiate to cover in this instance, like leave categories to cover all state employees who maybe aren't represented, then you need to put it into law.
So it could be discussed in labor negotiations. And has it been in the past?
We did have discussions on it this past contract negotiations.
And it was denied, or what?
In the spirit of negotiating in good faith and good faith bargaining, I don't want to go into specifics. I will say we, feel good. We made some progress on this particular issue, and we appreciate again the senator for offering some amendments to at least make sure that we're keeping things consistent.
And I'm not necessarily disagreeing with the issue at hand, but I think we do see this often, that there are negotiations that go on and then agreements are made, and then it seems that the things that are not achieved all of a sudden end up in this committee room and say, can you handle it this way rather through the bargaining process? Is that accurate?
I mean, I'll say we certainly always appreciate the opportunity to negotiate, terms and conditions of employment first before we take it to the legislator. That being said, I think this is the perfect issue, though, that if we have the ability to help state employees who are going through a terrible time like this, that we, do whatever we can to certainly do that. And I think this is a great example of that.
And I agree. I get the issue. I just talking broadly about the way that we do it. But thank you very much. Thank you.
Thank you, Senator. Do I have any other questions for Ms. Gilmore or Senator Gile? Nothing. That ends the hearing. Thank you. So the hearing for Senate Bill 109 has ended, and next we have my Vice Chair, Senator Klassmeyer. Oh, we found him. There he is. I didn't see him come in. Thank you. Let me back up. Next, we're going to have Senator Rosapep, Senate Bill 84, Teacher Degree Apprenticeship. Senator, you don't have a panel?
No.
Thank you.
In fact, I'm pushing for a very short hearing. So I'm not sure there are any witnesses signed up for oral testimony. Your staff would know, but I think there are. this is a bill on teacher apprenticeship, degree apprenticeships. It is identical to the bill that passed out of this committee last year and passed the Senate last year and didn't get taken up in the House. There's a cross file that had the hearing yesterday in the House. I don't know where that stands. But basically the idea is simply, we got a shortage of teachers. We're trying to expand apprenticeships generally, as everybody here knows, including as part of the blueprint, because we want 45% of high school kids to have completed the high school level of a registered apprenticeship by 2031. Well, a perfect place to do that is in teaching. And so what this bill does basically says that if at least 3 jurisdictions, school systems get together, and there at least one relevant union organize a joint apprenticeship and training council, which is how you have a union and management apprenticeship program like they do in the building trades we all know about, that the state would put up $500,000 for startup costs. That's an incentive to get people to work together. The bill is supported by MSEA. The bill is supported by the School Boards Association. There's some testimony and others. There's testimony from the Association of Teacher College Deans that have some technical suggestions, and I'm happy to work with them on. And the State Department of Education submitted a letter of information with a couple of technical questions, which I'm happy to talk to them about. The good news is, it's since last year, there have been continued meetings among school systems and the unions. Now, more unions are interested in this than were interested in the spring, particularly those representing paraprofessionals. And there are 5 or 6 school systems that have said that they're ready to begin discussions about all this. The basic idea is that the high school kids who want to go into this apprenticeship would take courses in high school, some of which we have now, about preparation for teaching. They'd specifically be focused on learning to tutor little kids. For the blueprint, we need lots of tutoring for little kids. So there's a lot of evidence that older kids are better at tutoring little kids than older people are at tutoring little kids. And so, and that came from the educators. That was a suggestion of the folks to do that. So those high school kids would work part-time for money as you do an apprenticeship. Could be after school, could be on weekends, could be in the summer, tutoring little kids, learning about education, how that works. Graduate from high school, hopefully having completed a lot of dual enrollment. Best case, they've gotten 60 college credits in high school with dual enrollment or AP or whatever it is. They graduate, they go directly to work as paraprofessionals in the classroom. And while they're paraprofessionals, they're completing their last 60 credits, or they may be more, of college credit to get their degree to be able to get a license to be a teacher. So you end up with, best case, folks 22, 23, 24, who have gotten their education degree and they have 3, 4, 5, 6 years experience actually in the classroom. So the idea is, between the on-the-job training, like any apprenticeship, and the classroom instruction, you're an even better professional than you would be otherwise. That's what the bill does.
Thank you, Senator. You do have one person in favor that's here.
Oh, great.
John Willems from the.
Oh, great.
It's the Maryland
God bless you.
Association of Boards of Education.
They've been very helpful. I want to say that the School Board Association has been terrific.
Chair Bidel, Vice Chair Klausmeyer, thank you. John Willems, representing the Maryland Association of Boards of Education, supporting this bill again this year, testified yesterday on the House cross file. Delegate Ken Kerr's bill, former local board member, always like to give them a shout out. And that hearing went very well, but that side of the street not as familiar with this bill, because this committee passed this legislation last year, again, with MABE support. Just a couple things I would emphasize. The blueprint is all about innovation and all about transformative change, and that requires innovative partnerships. And this bill reflects the need to, I think, codify innovative partnerships between organized labor, school systems, and institutions of higher education to build this teacher apprenticeship program and pipeline. There is a lot of federal money behind this initiative. Other states have already gotten in the lead on this. And Maryland certainly should be in that number. This is also based on learned experience. We had a multi-million-dollar grant program under the Maryland Leads grant program, so federally funded COVID relief funding implemented through the Maryland State Department of Education, and school systems were able to develop their own grow your own pilot programs. Many saw great success with getting high school students engaged in early education. There's data that's somewhat startling that many teachers teach in schools within 30 miles of where they went to school. And to me, that evidences the need to attract our young people to the profession of teaching through an apprenticeship pipeline. They can stay local, which of course avoids housing costs. They can attend local community colleges, which certainly pre-K-12 public education wholeheartedly supports. And we have this new, again, innovative partnership through dual enrollment in the blueprint that this bill really feathers into and folds into just perfectly. So we really urge a favorable report again from this committee this year. And to the extent you can help your House counterparts understand the value of this bill, that would be greatly appreciated. Thank you.
Thank you, John. We do have a question from Senator Hayes.
Yeah, thank you, Madam Chair. I'm trying to figure out why do we need to set up a separate program that costs $500,000 and to do this? Is there any way we could do this without setting up an individual program? And then also in the testimony, there's an informational letter from Maryland State Department of Education that says that they're not included as a part of the vetting, although they're responsible for certifying teachers. You testify it's just a little bit of information. That's a major organization that's left out.
Well, let me address that issue. Last year, the State Department of Education was not interested in engaging on this, frankly, and now they have a new director of CTE who is very forward-leaning and is working very closely with the CTE committee. When we passed the blueprint, one of the big discussions in the Kirwan Commission was making sure that CTE and career-related education was under an employer-focused group, which is the CTE Committee of the Governor's Workforce Investment Board. State Department of Education is represented, the superintendent is on the CTE Committee of the Governor's Workforce Investment Board. So it's cooperation with MSD. That's why I say I want to talk to the MSD folks because I think they're really raising a technical issue. Nothing in this bill changes certification for teachers. They will always still have control over it. It's just a way how people prepare to do this. The reason to set up a joint apprenticeship and training council is instead of having each school system have to set up its own program, there are huge efficiencies because we have the same certification requirements, we have the same graduation requirements, we have a statewide system. Things are done somewhat differently in locals, but basically education is set up under MSD approach. And so the idea is to set up a joint apprenticeship and training council with first movers. So every school system doesn't have to figure this out for themselves. And so then additional school systems can plug and play, saving everybody time and money. That's the essence of the idea.
I'm not gonna answer. The first part of the question was, why do we need this without setting up a program?
Why do we need?
Why do we need this without setting up a program?
Spending the money.
Why do you need money?
So you're creating a whole separate program to provide for this pathway to education, right?
We're creating a new pathway to become a teacher. Yes.
Right. And so what is preventing us from doing that without setting up a whole new program?
Well, it's not a new program. It's setting up an institution which is governed by the employers, the school systems, and the unions working together that does not exist now. That's the need to set up a new thing to make it happen because someone's got to do it. And the unions are not set up. I've had long conversations with the unions and with the school system. They're not set up to do this on their own. There's a need for them to work together and put together a system. If you use the analogy in the building trades, which I think is relevant, is if you think of union building trades or non-union building trades, individual employers do not have their own apprenticeship programs. ABC has a joint apprenticeship program for multiple employers in the non-union space. In the union space,
God, I don't want to believe, but so I think I understand now that you're explaining. So we set the entity that you're setting up.
Yeah.
Is that more like setting up a separate nonprofit to coordinate? Okay.
You got it.
All right.
You got it. I'm
Thank
sorry I
you.
didn't explain that well enough.
Thank you, Madam Chair.
Yeah.
Appreciate it.
Thank you for the
I
question.
don't see any other questions for the senator. Thank you very much.
Thank you.
That ends the hearing. I'm glad we found you.
Thank you, sir.
That ends the hearing on Senate Bill 84. We'll now have my Vice Chair, Senator Klausmeyer, Senate Bill 133.
Thank you very much, Madam Chair and the committee. Senate Bill 133, State Employees' Rights and Protections, Personnel Actions and Harassment Investigation of Complaints. Last year, we passed House Bill 309, which extended the time frame for a state employee to file a harassment complaint. Senate Bill 133 came about after the state's Equal Employment Officer Coordinator requested that more time be allowed to ensure that the office can adequately complete these investigations. This bill will expand the time frame from 30 to 60 days for an equal employment officer of the state to investigate a complaint involving employment decisions or harassment. It also provides up to 30 additional days to complete the investigation if written permission is received from the complainant. Employment and harassment complaints are often complicated and can involve many witnesses and victims that need to be interviewed. Investigating complaints requires time and diligence to ensure a fair, unbiased, and thorough investigation. There are also many external factors such as holidays, availability of witnesses, and other unforeseen events that can influence the duration of an investigation. Many state agencies have only a single staff to handle equal opportunity equal employment opportunity issues, which can mean that if a multiple or complicated complaints are filed, additional time is necessary. 30 days is not adequate amount of time to complete an investigation and prepare written recommendation. I also have requested an amendment be drafted to address concerns raised by the Department of Budget and Management. As you can see in DBM's testimony, they request an amendment to state that the time limit to impose disciplinary actions does not begin until the appointing authority receives the recommended decision by the Equal Employment Opportunity Officer. This is an understandable concern, and I have provided the amendment to the committee as a sponsor amendment. So thank you very much, and I hope for a favorable report.
Thank you very much, Senator. Do I have any questions for Senator Clausmeyer? Thank you for presenting the amendment also. Thank you. So that ends the hearing on Senate Bill 133. Next, we have Senate Bill 192. Senator Kramer is the sponsor. And if you have a panel, please bring it up.
Good afternoon, Madam Chair, Madam Vice Chair, members of the Senate Finance Committee. For the record, Ben Kramer to introduce Senate Bill 192. Colleagues won't spend a whole lot of time on this because it should be a little bit familiar. We had the bill before us last year. What you're seeing this year is a trimmed down version of that legislation, and I could be mistaken, colleagues, but I don't believe there's any opposition to this bill, so hoping to get it across the finish line this year. And what the bill simply does is provide a category of hardworking women and men who are in state government the opportunity, if they choose, to bargain collectively. So we have a category of middle management, basically, workers. They're referred to in their category as supervisors who are not given the opportunity under state law to do what tens of thousands of other workers in the state can do, And that's if simply they choose to bargain collectively, they can do so. Workers in the same category in multiple states across the country have this ability right now. They can do what we are seeking to do here in Maryland. There are multiple counties, local jurisdictions in the state where workers in this category can do what we are simply asking this body to afford these hardworking people that right now can't. Finally, colleagues, no worker should have to make the choice in advancing in their career into this mid-level management to give up their right to participate in collective bargaining. And yet that's what they face if they choose to take on this critically important state role. And by the way, very often these are the people who step into the shoes of the workers when they're out sick, they go on vacation. They're the ones who are filling the gap and doing that work. So colleagues, with that, I would ask for a favorable report so that we do right by these hardworking women and men in state government. Thank you, Madam Chair.
Senator, you're correct. There is no one that is unfavorable on our report today. So good
Great.
job.
Thank you.
Denise, you want to go next?
Sure. Thank you, Madam Chair. Denise Gilmore, AFSCME Maryland. Thank you to Senator Kramer for introducing this bill for us. Just as the senator said, this is an enabling legislation. When passed, it'll allow for the employees who are currently in bargaining unit S for supervisor to have a say in if they want a union and which union they want to have represent them. This is separated out from other bargaining units that the state has. The state already has a unit, for instance, for like confidential employees where those folks would go. So this is really just for those supervisors who, don't have hiring or firing power. They are experiencing many of the same issues as folks that they supervise who are in represented units. We're seeing supervisors organize now, I think, because they're under the previous administration. There were, some bonuses that were, for instance, like longevity and retention bonuses that were, given out to represented units and not supervisors, right? Obviously, coming out of the pandemic, they experienced a lot of the same health and safety issues and didn't have that strong voice and strong say. So we're really proud of these workers for coming together and saying now's the time to really organize and get a collective bargaining agreement. I'll just close by saying, the legislator has an ability to expand collective bargaining rights to thousands of workers this year. By voting yes, these workers are going to finally get a say, which is exactly what we need in certainly an environment where we're struggling with recruitment and retention right now. What it'll do to help with morale is really important. So we appreciate certainly your support and urge a favorable recommendation on Senate Bill 192. I think I'll hand it over to Ms. Nicole now, if that's okay.
Good afternoon. My name is Nicole Spencer, and I'm a Field Supervisor 1 with the Division of Parole and Probation here in this great state of Maryland. I've been a proud AFSCME member, and I've worked for state services for 25 years. I'm proud to do this work, keeping the community safe and giving people the tools that they need to successfully reintegrate back into our communities. In addition to supervising agents' caseloads, I facilitate the Gun Violence Initiative orientation, where we provide resources for jobs and anti-violence training. The significant change in responsibility when I became a supervisor was a big challenge, but one that I gladly accepted because of how important the work is. I'm so proud to say that I've raised 5 children here in Maryland, one of whom has special needs. My child requires extra care, but the small teeny-weeny increase in the salary does not make up for the extra time that is due to my increased workload. I do not receive overtime pay, only comp time. And unfortunately, my childcare provider does not accept comp time. It's no surprise that many supervisors are deciding to leave. And while other employees are avoiding the promotion process altogether, without collective bargaining rights, we are left with no mechanisms for addressing issues that affect us all. When we raise concerns, we are told that we'll look into them, but there's no way to follow up. When we receive policies that require training, we're told training will come, but we have no way of making sure that it does. The answer is simple. It's expanding